In 1896, Barron was brought up again, and Brown versus Walker, and they broached it on self-incrimination. And now the book, I'm talking about the book, the constitutional book, because it explains in detail, it actually annotates what the court is saying. In 1956, the court reaffirmed the Brown decision in Ullman versus United States. It rejected the defendant's argument that the impact of the disabilities imposed by federal and state authorities and the public in general, such as loss of job, expulsion from labor unions, state registration, and investigation statutes, passport eligibility, and general public opprobrium, is so oppressive that the statute does not give him true immunity. The statute, like the Fifth Amendment provision, protects the witness only from having to give testimony which may possibly expose him to a criminal charge. That is what the book says. They also said, since Congress needs not grant immunity from state prosecution in order to compel testimony, the question arises whether it may do so if it wishes. Right? The control over evidence admissible in state courts is traditionally a question of state power, and even the Supreme Court, in administering the Due Process Clause, has been reluctant to interfere with this state prerogative. In Adams versus Maryland, 1954, the court held that Congress could, under the supremacy doctrine, forbid a state to use testimony given before a congressional committee. Adams had been summoned before the state Senate Crimes Investigation, that's Kefauver Committee, and had bared his soul concerning his boob-making activities.
What would that be?
Boob.
He was making implants?
But it's a misprint.
Oh.
That's what it says, the boob-making activities.
Yes, it does.
Well, maybe he was into porn or something, I don't know. But anyway, the state of Maryland, which had been unable to get other evidence against Adams, read the transcript of the committee hearing into the trial record as a confession, and he was convicted on illegal gambling. The Supreme Court reversed the conviction on the ground that 859 forbade the use of such testimony, quote, in any criminal proceeding against him in any court, end quote. The term there is any court. While Congress could not compel testimony under the statute, such testimony as was given was protected, and the phrase in any court included state courts as well as federal. Forbidding such use of the testimony was held to be necessary and proper way of securing testimony. The Immunity Act of 1954 uses the same language, and the Adams interpretation was reaffirmed in the court in the Ullman case. In the present case, a federal grand jury was investigating charges against a railroad that had granted discriminatory rates and rebates. Brown, who was the officer of the railroad, was called as a witness but refused to answer certain questions on the ground that the answers would tend to accuse him and incriminate him. He was adjudged in contempt for his refusal to answer. Now, I'm going to read what the court says. Mr. Justice Brown delivered the opinion of the court, saying, in part, it is true that the Constitution does not operate upon a witness testifying in state courts. So, therefore, if you're in a state court, you can't use the Fifth Amendment. All right? Since we have held that the first 8 amendments are limitations only upon the powers of Congress and the federal courts and are not applicable to the several states, except so far as the 14th Amendment may have made them applicable, and they cite Barron versus Baltimore, 1833. There is no such restriction, however, upon the applicability of federal statutes. The court here quotes a supremacy clause in Article 6. It says, the act in question contains no suggestion that is to be applied only to federal courts. It declares broadly that no person shall be excused from attending and testifying before the Interstate Commerce Commission on the ground that the testimony required of him may tend to incriminate him. But no person shall be prosecuted or subjected to any penalty or forfeiture for or on account of any transaction, matter, or thing concerning which he may testify, etc. It is not that he shall not be prosecuted for or on account of any crime concerning which he may testify, which might possibly be urged to apply only to crimes under the federal law. But the immunity extends to any transaction, matter, or thing concerning which he may testify, which clearly indicates that the immunity is intended to be general and not to be applicable whenever and in whatever court such prosecution may be had. Now, it's quite lengthy. It goes on to more and more, but I won't bore you with a lot of that stuff. But anyway, they had a dissenting opinion, and they, Justice White and Gray and Shiras wrote and Field wrote a separate dissent to that, which amounted to nothing, but the case was decided anyway. Now, to show you how powerful Barron was in Powell versus Alabama in 1932, and then in Palco versus Connecticut in 1937, Barron was brought up again. And here's the comment in the book. When the decision in Powell versus Alabama appeared that a long struggle to nationalize the Bill of Rights might at least be bearing fruit. You got that? Nationalizing the Bill of Rights? The Bill of Rights in Barron versus Baltimore was strictly for the United States and not to anybody in the states, not to the states, nobody but only those 207 inhabitants of Washington, D.C.
Oh, what is Barron's, by the way, or who is Barron's?
Oh, on the that was 32 U.S. 243. It was on a writ of error to the Court of Appeals for the Western Shore of the state of Maryland. And the guy used the provision in the Fifth Amendment declaring that private property shall not be taken for public use without just compensation. And he brought it in because the city of Baltimore, under its corporate title of mayor in the city of Baltimore, to recover damages to the wharf property of the plaintiff arising from the acts of the corporation. Maryland is a corporation. Baltimore is a corporation. If people would only realize that the entire government anywhere in this country is a corporation, that makes everything totally different. They are a corporate entity.
All right. How does that impact them, though, if they understand that, in
because
fact,
they're part of the corporation, and that's why they are drug into the court, and everything is denied. They have no inalienable rights or unalienable rights. They only have granted rights by the corporation because they're presumed to be a corporate member.
So, okay.
So, the case was instituted in the plaintiff in error against the city of Baltimore under its corporate title of the Mayor and City of Council of Baltimore to recover damages for injuries to the wharf of this guy arising from the acts of the town. And they really messed up his border, his wharf, everything, and he couldn't even use it, couldn't do any business off of it or anything. And then he brought up the Fifth Amendment. Well, gee, the city took my property and never reimbursed me for it under the Fifth Amendment. Okay? Well, he's in Maryland. Okay?
Right.
So he's thinking, okay, the Fifth Amendment applies. The Bill of Rights apply to me. Well, the court goes in and explains every one of the Bill of Rights and says they do not apply to you. You are not a part of the United States that would be contravening the Fifth Article of the Amendments, and therefore your private property can be taken for public use, and you can't use the Bill of Rights. It don't apply to you. And it goes in through every one of them, and Justice Marshall came out, and it says, the plaintiff in error contends that it comes within the clause in the Fifth Amendment to the Constitution which inhibits the taking of private property for public use without just compensation. He insists that this amendment, being in favor of the liberty of the citizen, ought to be so construed as to restrain the legislative power of a state, as well as that of the United States. If this proposition be untrue, the court can take no jurisdiction of the clause. The question thus presented is, we think, of great importance, but not of much difficulty. The Constitution was ordained and established by the people of the United States for themselves, for their own government, and not for the government of the individual states. How do you like that?
You want to translate that?
That means that, like I said, when Congress, which is the United States, set up the Bill of Rights, it was only for them and their constituents in the District of Columbia for their own government and not for any of the governments of the individual states.
Well, what
It says each state established a constitution for itself, and in that constitution provided such limitations and restrictions on the powers of its particular government as the judgment dictated. The people of the United States, now they're talking about the states, so this is where people have got to learn the United States is not the United States, what they believe to be. The United States is that little bunch of criminals, the 535 people called Congress. In other words, Congress is doing business as the United States. Plain and simple. That's the bottom line of the whole thing.
Now, is the United States of America a different thing?
Nope. Such as loss of job, expulsion from labor unions, state registration, and investigation statutes, passport eligibility, and general public opprobrium is so oppressive that the statute does not give him true immunity. It actually annotates what the court is saying. In 1956, the court reaffirmed the Brown decision in Ullman versus United States. It rejected the defendant's argument that the impact of the disabilities imposed by federal and state authorities and the public in general. In 1896, Barron was brought up again, and Brown versus Walker. And they broached it on self-incrimination. And now the book, I'm talking about the book, the constitutional book, because it explains in detail the statute, like the Fifth Amendment provision, protects the witness only from having to give testimony which may possibly expose him to a criminal charge. That is what the book says. They also said, since Congress needs not grant immunity from state prosecution in order to compel testimony, the question arises whether it may do so if it wishes. Right? The control over evidence admissible in state courts is traditionally a question of state power, and even the Supreme Court, in administering the Due Process Clause, has been reluctant